So imagine this. A woman in Uganda is at a bar in the evening with a group of friends. A man decides she or the group looks gay and attacks her. The police arrive, and rather than arresting him, they take her into custody. She spends 2 nights in jail, no charges filed. Sometime after the release, she finds her landlord has evicted her, citing unnatural offenses. She was never convicted, never officially punished by the state, but anti-gay laws have shaped her life in irreversible ways. Or take another case. A police raid on a health clinic leads to the arrest of several men seeking voluntary HIV testing and treatment. They are charged with unnatural offenses, spend 10 months in pretrial detention, only to be released. Again, the record would show no legal conviction, but the impact is undeniably punitive. So the core question here is, what counts as enforcement? Were these laws really enforced? If we measure law enforcement by convictions, the answer might be no. But if we shift our focus beyond courtrooms and prison sentences, we see a different reality, one which requires urgent and sustained attention, one where anti-gay laws function as tools of surveillance, punishment, and societal control without ever needing a single conviction. And this challenges a common assumption, one shared across both socially conservative and liberal perspectives, that sodomy laws are unenforced or even unenforceable. These laws are often dismissed as a primary concern because conviction rates are low, or because their primary targets are assumed to be cisgender men engaged in perhaps public same-sex activity. But this narrow legal lens misses the bigger picture. So previously, I've worked on the development of the anti-homosexuality bill and act from the colonial kind of era sodomy legislation in Uganda. But today I ask a different question, which is, how do these laws extend their reach beyond arrests and the courtroom? What constitutes enforcement of sodomy legislation and thereafter decriminalisation? I rely on a wide range of primary and secondary data in order to make this intervention. When we think about the enforcement of anti-gay laws, it's easy to imagine a straightforward process. Someone is arrested, charged, and prosecuted under the law. But in reality, these laws are doing something much larger than just criminalizing specific acts. They are criminalizing entire identities, shaping national narratives, and legitimizing everyday forms of discrimination. Uganda's sodomy laws trace back to British colonial rule, specifically Section 377 of the Indian Penal Code, which spread across the British Empire. These laws weren't a benign product of their time. They were about controlling populations, enforcing Victoria-era gender and sexual norms through which indigenous peoples could be reconstructed as barbaric or deserving of control, civilization, and punishment. That is to say, these laws are about asserting colonial dominance over indigenous cultures. But why are these laws still in place today? Many former British colonies have repealed them, yet Uganda and other nation states have instead strengthened them. Here, the function of these laws has changed. They are no longer just colonial impositions. They have been reactivated and repurposed for contemporary political, economic, and moral agendas. One of the most important things to understand is how anti-gay laws are used to build a national identity. In Uganda, politicians frequently invoke homosexuality as a foreign threat, a Western import that endangers traditional values. This serves several functions and has been argued to serve as a distraction from governance failures. By positioning LGBTQ people as a cultural enemy, leaders redirect public frustration away from issues like economic hardship or corruption. It's also been argued to consolidate political power, so leaders gain favor with religious institutions and international allies who support anti-gay and anti-gender policies. But I've argued in my work that they don't just serve consolidation or distraction functions, but that they are a part of a broader reactive politic, one that positions LGBTQ identities as an extension of Western geopolitical control. Framing this as homophobic nationalism, I argue that it emerges in Uganda in response to transnational funding flows. Western governments and NGOs that support LGBTQ rights are framed as engaging in ideological warfare, using queer visibility as a means of exerting influence over African nations. This is the international weaponization of homo-nationalism, or how LGBTQ rights can be repurposed by Western nations to justify financial and militaristic intervention in countries outside of Western Europe and North America. This allows Ugandan politicians to argue that resisting LGBTQ rights is not just about morality, but about resisting neocolonial control. Homophobic nationalism is not merely about domestic political gain. It is also about consolidating ideological weaponry against the perceived foreign threat. LGBTQ Ugandans are positioned as proxies for Western influence, imagined as an emerging, globalized constituency that threatens the moral and political fabric of the nation. This framing justifies legal repression and allows leaders to cast their opposition to LGBTQ rights as an act of sovereignty rather than discrimination. The phobia of homophobia, in this case, is a politicized fear in which stopping the spread of the imagined community preserves the inviolability of the state. Rather than seeing homophobic nationalism as a byproduct of state control, we should recognize it as an active strategy of geopolitical positioning, one that transforms LGBTQ people into symbols of Western incursion rather than individuals with rights or agency. Anti-gay laws don't just criminalize same-sex intimacy, they construct a moral boundary between real Ugandans or real Africans and those deemed corrupt, deviant, or foreign. In this way, the law becomes a tool of social division, reinforcing a binary us versus them logic. While I won't get into this here, my monograph, The Economies of Queer Inclusion, actually explores the us versus them logic, which I argue also exists for Western advocates of gay rights, to the great detriment of African movement making and queer political leadership. But legal repression doesn't always rely on direct criminalization. So while I found in my data that I've collected since publishing this book, a sharp and actual uptick in arrests for unnatural offenses since 2009, I argue that there are also other mechanisms of enforcement to which we must attend. This first occurs through proxy laws, so other legal provisions that are weaponized against LGBTQ individuals without explicitly naming them. So for example, the Anti-Pornography Act, which didn't gain as much kind of international traction or attention, which was passed in 2014, the same time that the Anti-Homosexuality Act was originally passed. The Anti-Pornography Act was used to police gender expression and disproportionately targeted women and queer people. But additionally, laws on public indecency and disorderly conduct, licensing, and organizing regulations all allow police to harass, detain, and intimidate LGBTQ people under the guise of upholding social order. So this means that even if sodomy laws were repealed, the broader architecture of anti-queer policing would still exist. True decriminalization isn't just about removing the specific legal penalties. It's about dismantling the entire system of social surveillance and moral regulation that these laws support. Anti-gay laws function in ways that are often invisible, shaping daily life without ever needing to be formally applied. Their power lies in their ability to create fear, justify discrimination, and regulate behavior through indirect means. When that bar fight occurred in the opening anecdote, the arrest expressed a tacit disapproval of the build and aesthetic of my company. So this actually happened when I was in Uganda, and I was in the bar. So it wasn't a direct indication that she had ever actually engaged in same-sex activity, an unnatural offense. The arrest signaled that her public presence was the unnatural offense. As such, anti-gay laws reach the psyche of the people and the police. When I probed why the attacker was not arrested, an arresting officer joked that this kind of woman was not vulnerable due to her physical appearance. But the invisible reach is one that also structures panoptic enforcement. The Anti-Homosexuality Act, through its promotion of homosexuality clause, enabled panoptic policing to formally occur, making it a notable legal intervention. People, landlords, employers, healthcare providers, educators, even family members, are held at the punitive arm of the state to become enforcers of this law, making decisions based on the perceived risk of associating with LGBTQ people. A doctor may refuse to treat a queer patient, not because the law compels them to refuse, but because they fear police scrutiny about the order of their priorities. So they might have the priority to the medical oath, but they also have an oath of citizenry to uphold laws. A parent may need to evict and report their child for criminal engagements. This means that even when the state is not actively policing, the law is still being enforced at every level of society. These laws extend their reach through the chilling crackdown on activism and essential services. The result, life-saving medical care becomes inaccessible, disproportionately harming those already most vulnerable. The annual crime report data in Uganda illustrate this well. Cases categorized under unnatural offenses historically have included a range of acts. Bestiality, consensual same-sex act, and same-sex sexual assault are all lumped together under one broad classification as unnatural offenses. The deliberate vagueness makes it impossible to track how the law is applied and who it targets. But a key shift happened when the Anti-Homosexuality Act was passed, which is that bestiality was actually disaggregated from the category of unnatural offenses, leaving only homosexuality under this classification. This legal shift matters because it cements the idea that homosexuality itself is inherently and very specifically unnatural, and therefore it's socially derived, rather than any specific act of sodomy. The law, even without convictions, creates a criminal class, people who are under suspicion always, who can be arrested and detained at any time, and who are marked as threats to the public. Finally, anti-gay laws make extra-legal punishments seem acceptable. If the state criminalizes LGBTQ life, it legitimizes homophobic vigilante violence. When a queer person is attacked, their attackers can claim they were simply defending cultural values or protecting their community. Chillingly, they can launch no defense at all, as interpersonal violence becomes a common sense response, just as criminal justice normalizes the state's extreme violence. So if the state rarely enjoys conviction based on sodomy laws, does that mean that the laws don't matter or that they're ineffective? Quite the opposite. Their true power lies in how they reshape everyday life, embedding fear and exclusion into the societal imagination. Understanding this invisible reach is essential if we want to move beyond criminalization and decriminalization and towards actual safety and freedom. So what is decriminalization? How can we track harm or code enforcement as scholars when the law is operating outside of traditional criminal justice? I argue that it's to the benefit of our scholarly and ethical engagements to recode enforcement so that we can move towards a comprehensive decriminalization. We often think of decriminalization as a simple legal process, repealing a statute, striking down a law. But if enforcement is diffuse, what does it really mean to decriminalize homosexuality? The law has strengthened to enact violence to which queer people are already globally acquainted. If parents disown their children, if landlords still evict queer tenants, if police still monitor health institutions, has anything truly changed once a particular law is repealed? Yet, queer abolitionist analyses are poised to precisely engage this question. We need to question what justice can look like when legal apparatuses ensure marginalization happens through socialized policing, economic exclusion, and moral surveillance. And it's not an unrelated question to what queer justice needs in order to take shape around the world, including here in the UK, where such exclusions and policing occur on streets, in bathrooms, homes, and in work and educational contexts. Challenging sodomy laws means looking at, but also beyond, the law itself. It requires us to recognize the full network of enforcement, one that includes the punishment suffered not just at the hands of the state, but also at society at large, as well as the lack of resources, recognitive and material, distributed to attend to the needs of the marginalized. Therefore, repealing anti-gay laws is only the first step. Legal decriminalisation without social change still leaves queer people unsafe, and policy shifts don't automatically undo the harm caused by years of criminalization and imprisonment. Decriminalisation actually must go further. It must be about dismantling the systems that enforce exclusion, fear, and violence. And abolition requires attention to the roots of violence and marginalization, the coloniality of power, in this case, that has fomented homophobic nationalisms, and the coloniality of gender that presupposes a sacrosanct sex-gender binary. Decriminalization, then, is about more than the law. It's about undoing the societal impulse to demarcate people as criminal or upright to other people based on perceived or real nationalist precarities. It's about building abolitionist democracies, creating multivalent infrastructures of protection that shield not only LGBTQ people from socioeconomic exclusion, but also the broader Ugandan public from neocolonialism and authoritarianism. Without adequate resourcing and true democratic access, people may be free from arrest, but they will not be free from fear. And while a completely necessary harm reductionist measure, if we only focus on criminal legal victories, we risk missing the deeper struggle, the fight against a colonial logic that weaponizes criminalization and punishment against the moral and social order of those supposedly requiring civilizing. Therefore, as recoding enforcement means widening our recognitive power to consider various punitive inlets, theorizing decriminalization means more than erasing a particular law, but rather including the broader effort to undo binary logics that uphold criminalization, cis heterosexism, and othering. It's the investigation of anti-gay laws that we are enabled, it is in the investigation of anti-gay laws that we are enabled to do exactly that.